Good afternoon, for those of you at least who are in the East Coast time zone. My name is Natalie Roisman. I'm the Executive Director of the Institute for Technology, Law, and Policy at Georgetown Law. Really delighted to have you all with us today. We have a great program lined up, and so let's get right to it. We are here for the next installment of our ongoing AI Governance series, which is presented by the Global TechNet Working Group of the Institute for Technology, Law, and Policy in partnership with the Wikimedia initiative of the Yale Information Society project. With that, I'm going to turn the microphone over to Ben Gitzinger, who is one of our student research assistants this summer at the Tech Institute.
First, we'll hear remarks from Russ Hanser. Russ is Associate Administrator for Policy Analysis and Development at the National Telecommunications and Information Administration, located within the U.S. Department of Commerce. He previously served as a staff member at the Federal Communications Commission, as NTIA's Director of Communications Policy Initiatives, and as Senior Policy Advisor to the Department of Commerce. He also worked in private practice and has held various leadership positions in the Federal Communications Bar Association. Russ holds a bachelor's from Amherst College, a JD from Harvard Law School, and a master's in global policy from Johns Hopkins University. After Russ gives his remarks, then we'll hear from our esteemed panel. In the panel, we have Anupam Chander, who is the Scott K. Ginsburg Professor of Law and Technology at Georgetown University Law Center. A graduate of Harvard College and Yale Law School, Professor Chander is an expert on the global regulation of new technologies. He serves as an adjunct senior research scholar at Columbia University's School of International and Public Policy, a faculty advisor to Georgetown's Institute for Technology, Law, and Policy, where he chairs the Global TechNet Working Group, and is a faculty affiliate of Yale's Information Society project. For the 2023-2024 academic year, Professor Chander will be visiting scholar at the Berkman Klein Center's Institute for Rebooting Social Media. Nikolas Guggenberger is an assistant professor of law at the University of Houston Law Center, who specializes in antitrust, law, and technology, privacy, and regulation. Prior to joining UH, he was a lecturer in law at Yale Law School and executive director of the Yale Information Society project. He holds a PhD and JD equivalent from Freiburg University, as well as an LLM from Stanford Law School. Mehtab is a resident fellow and the program director for the Yale Wikimedia Initiative on Intermediaries and Information, where her research focuses on intellectual property, data governance, and AI ethics. She previously was a fellow at the Center for Technology, Society, and Policy, and a research grantee at the Center for Long-Term Cybersecurity at UC Berkeley, where she studied the implications of the use of AI in hiring. She holds an LLM and JSD from University of California, Berkeley School of Law. Neel Sukhatme is an Anne Fleming Research Professor and Professor of Law at Georgetown University Law Center, where he co-directs the Georgetown Law and Economics Workshop Series and serves as a faculty advisor to Georgetown's Institute for Technology, Law, and Policy. He also has been recognized as an Andrew Carnegie Fellow for 2021 through 2023 and serves as the Thomas Alva Edison Visiting Scholar at the U.S. Patent and Trademark Office. In 2020, Professor Sukhatme co-founded Free Our Vote, a nonpartisan nonprofit organization that seeks to restore voting rights for people with past felony convictions. He holds a BS in computer science from the University of Illinois, a PhD in economics from Princeton University, and a JD from Harvard Law School.
Thanks, Ben. Russ, it's all yours.
Sorry, I've only been doing this pandemic thing for about 3.5 years now. So apologies for that. So thank you, Ben, and thank you everyone for having me. As some of you in the audience and the panel know, that Natalie and I were law partners before taking our current jobs, law partners and work spouses for more than 13 years or so. I've often thought that it would be ideal for us to have positions where she has to say nice things about me or have other people do that, and I have no obligation to reciprocate. So achievement unlocked there. But I will say, I will applaud Natalie and her stewardship of the Institute. I think she was clearly an ideal candidate for this position and has shown that over her 6+ months in the job. So congrats to Natalie and to the Institute. So on our topic for today, I am really glad to be here with you. I'm always very happy to see lots of smart people showing up to talk about this issue. Like many of you, I have spent my career working on challenging issues at the intersection of law and policy, economics, technology. But for me, at least, AI is probably the most challenging of all of these, both because the issues are complex and the underlying questions are so varied and require such different kinds of expertise, and also because there's an urgency to thinking them through that I haven't seen with as many issues or with many issues at all. So again, I'm thrilled to be here to talk and to help facilitate this discussion. I thought I'd start by telling you all a little bit about NTIA and then a little bit about the office that I lead, OPAD, the Office of Policy Analysis and Development, and then turn to our request for comment on AI accountability policy and why we at NTIA in particular are so focused on AI right now. So to start with NTIA, NTIA is, as you heard, housed within the Commerce Department. We do a lot of different things. One role that NTIA plays is it manages federal use of spectrum, the use of radio spectrum by federal agencies, counterpart to the FCC, which plays the same role with respect to commercial use. That's the last time I'll mention spectrum probably in this talk, but that's one major thing NTIA does. We also, especially in the last few years, and maybe more broadly, especially since 2009 or so, administer a bunch of broadband and digital equity focused grant programs. Most significantly in the COVID era, we've gotten about $50 billion in grant funding that we've been responsible for implementing and using to close the digital divide, a hugely important part of our mission. Most relevant for my talk and for the office that I now lead is that NTIA by statute is the president's principal advisor on telecommunications and information policy issues. So traditional telecom issues, I see some of you in the audience who I've known for a long time, who are historically, like me, telecom people, but then also these information policy issues like privacy and most critically here, AI. There are, I will note, both domestic and international components to that policy work. My office tends to focus on the domestic policy issues, although increasingly our office and the International Affairs Office work hand in glove and usually in teams that are spanning both offices. So let me talk a little bit more about OPAD in particular for a minute. We're a relatively small office. We have right now 14 full-time people in OPAD. We plan to grow by 6 or 8 people or so in the next few months. So that's a pretty significant expansion coming up. We also are lucky to have what we call IPAs, but which are best described as academics and others from outside of the government who come to the government under a law called the Intergovernmental Personnel Act and work with us. And they get experience working for government and we get to draw on their great expertise and energy. Right now it's summer, so we are also flush with interns, some of whom I think are watching this as I speak. They are actually all integrally involved with our AI work this summer, unsurprisingly, given how much of a focus it's been. OPAD works on a really wide range of issues. I mentioned privacy. We do cybersecurity policy. We do standard telecommunications policy issues. We work on digital equity and inclusion. We do supply chain security and national security issues, things like team telecom, which some of you know what that means. For others, it's a process by which the executive branch participates in the FCC's review of telecommunications transactions that will affect, will give rise to or increase international ownership of American telecommunications infrastructure. We do competition policy. We do platform governance and Section 230 issues. We do some intellectual property work. We work on 5G and 6G wireless. And of course, we do this work on AI and emerging technologies. So those are the topics. What do we do on those topics? The activities we work on are likewise pretty broad. We do a lot of stakeholder outreach. We are probably every day by phone, by Zoom, in person now working and meeting with stakeholders who have views for us. And these may be companies, they may be civil society, they may be other government entities with views, they may be foreign government entities or representatives of multilateral institutions. So we are very much in the game of talking about what our policy views are, what other people's policy views are, and getting input. NTIA, I think, is known, among other things, for multi-stakeholder gatherings. We work on large and small multi-stakeholder processes to develop consensus solutions and to drive toward best practices and so on. We've done that in a variety of areas, and that I think will continue to be part of our mission, NTIA's mission. We issue requests for comment. We're going to talk about one of those at some depth in a few minutes, but we've issued requests for comments on a wide range of topics and will continue to do so. We write reports, formal reports. A few months ago, some of you may have seen a report we issued on the state of competition in the mobile app ecosystem. That's a report we issued in response to a request/requirement in President Biden's competition executive order from 2021. We're going to be writing a report in the coming months on privacy, equity, civil rights, which is another area in which we have sought comment, and then, of course, on this AI accountability workstream. And then we also issue policy recommendations in other ways, white papers, other potentially draft legislation, other mechanisms. We, worth noting, have no rulemaking authority. We have no regulatory power. I cannot fine anybody unless they want to cooperate and give me money. But we operate by the power of ideas and by pushing the policy debate forward. We also engage a lot on internal or inward-facing, government-facing activities that aren't as visible to the outside world, but lots of talks with other agencies in formal and informal contexts to try to figure out what the executive branch's collective view is going to be on a set of issues. As you can imagine, different parts of the government bring different equities to issues. I'll talk about that in a few minutes as well. And then we engage internationally on bilateral basis and a multilateral basis with partners around the globe. I mentioned these because this tool set is not just kind of a intro to NTIA or OPAD 101, but it's the tool set that we bring to artificial intelligence policy. And I think we will be using most or all of these tools in the coming years as we face AI and other emerging technology issues. So I'm going to pivot now and talk specifically about the AI accountability request for comment. I want to emphasize we've engaged on AI on numerous fronts. The AI accountability RFC is not the only thing we are doing right now on this, but it is probably the most significant work stream going on within NTIA on AI at the moment. I'll note that the RFC is the brainchild of Ellen Goodman, who is an IPA. She's one of these academics who's been on loan to us. She's on loan from Rutgers Law School. This is her baby. We've had a lot of people working on it, but without her, we'd be in a very different place on these issues. So we owe her a huge debt of gratitude on that. The work stream began, I want to note, well before ChatGPT took the wider world by storm, sometime in late 2022, I guess. We'd been working on this for about a year before that happened. I think I first spoke with Ellen about coming on board and doing this work in December 2021, after I received an email from Phil Weiser, who many of you know, asking whether we would talk to a friend of his who has a great idea for coming on board as an IPA. Those of you who know Phil know that when he says, would you do X, you try to do X. It's going to be for your own good and everyone else's. So we did that, and we were extremely fortunate to get Ellen on board and have her on our team. So there was a long period of work on the RFC that led to a kickoff on April 11th and formal publication of the request for comment on April 13th in the Federal Register. And as many of you have probably seen, the RFC contains a pretty broad range of questions. I'm not going to list them all, but broadly speaking, we're seeking input on what policies can support development of AI audits, assessments, certifications, and other mechanisms to create earned trust in AI systems. I underline earned trust, two-part word. We want the world will work better when AI is trustworthy, it is worthy of our trust, and it will work better when AI that is trustworthy is in fact trusted. Having trustworthy systems that nobody trusts will mean foregoing benefits of AI. So, and conversely, trusting AI that's not trustworthy will presumably lead to harms. So we want earned trust, and both of those words are important. What are the subjects? So the kinds of questions we ask include, what are the subjects, what issues to be subject to audits, assessments, certifications, and so on? Should we be doing these or urging them for safety, for consistency with privacy and other human rights, for the presence of human alternatives and fallbacks when systems claim that there are human alternatives to automated systems? Should we be using audits and other mechanisms to gauge the effectiveness of an AI system, i.e., does it do what it says it does? Should we be looking for certification or audits or assessments of whether an AI system implements appropriate mitigations for potential harms, and what other issues? We also ask when in the AI system's lifecycle we should be subjecting that system to audits, assessments, and other kinds of accountability measures. Should we do it in the development stage, in the deployment stage, in the post-deployment stage, toward the end of the lifecycle, all of the above? these questions may have different answers depending on the kind of system we're talking about. And we're trying to get a view on when accountability mechanisms are going to be most useful. We also ask whether accountability assessments can have meaningful impact absent legal requirements and enforceable standards. We ultimately will be making policy recommendations. Those could include recommendations for mandatory requirements. Again, we cannot impose those. We can only recommend them. So we could recommend that, but we're trying to find out what needs to be, what if anything needs to be mandated, and what kind of ecosystem could be built without such mandates, if any. We also want to know what lessons we can learn from accountability ecosystems in other fields. The financial system is the one that comes to mind and comes into the conversation most frequently. That's an area where audits and other assessments play a large role. What can we learn from the role that it plays, that they play there? We ask about whether we should impose pre-release quality certification requirements, or whether there should be such requirements. I say we as the government, not we as NTIA there. And we ask how government can best work with the private sector. And then we ask questions about deep issues on how data sets are created and how we can assess and ensure adequate access to the kinds of high quality data sets needed to build trustworthy AI and then to assess that AI. There are many more questions. In all, the RFC includes 34 questions, but because Ellen and I are both attorneys, almost all of those have subparts. I don't know exactly how many questions there are when you count the subparts, but they were enough to keep, I'm sure, many people busy writing comments for about 2 months. Comments were due on July 12th, and we received kind of a wave of comments. We received over 1,400 comments. Roughly 200 of those are from groups that identify themselves. The rest are mostly from individuals. Those individuals are everything from person on the street to distinguished professors in the fields that are relevant to AI policy. It's an enormous response. For those of you who are paying attention to our request for comment on the BEAD program, the $42.5 billion broadband grant program, and some related programs, that RFC got us somewhere in the range of 500 unique comments. So we are working really hard to process the record we've collected. We have a large team devoted to that. We're using a variety of tools to do that, and making a lot of good progress. So that's great. Our plan is to issue a report later this year. That I'm confident that's going to happen. There are a couple of reasons why it needs to happen, among them being that Ellen is going to be returning to academia, but also this is, as I said, an important issue with some urgency to it. So we are working really hard, and we'll continue to work hard on getting that report out. So I want to then talk for a few minutes about why NTIA. So as you've surely seen, there's a lot of government stakeholders working on AI, and some of them are working within their vertical sphere, whether that's food and drug law or employment discrimination or whatnot. And there are also a lot of government entities looking horizontally at these issues across the board at what needs to be done to ensure trustworthy AI, to promote trustworthy AI, what kind of governance mechanisms might we want to implement, and so on. So why NTIA? And I would say the reasons NTIA are here are because of the value we bring to the discussion and the values that we bring to the discussion. So first, the value. As I mentioned before, we are by statute the president's principal advisor on information policy issues. There's no information policy issue right now as prominent as artificial intelligence is. And I don't think there's a better collection of tech policy expertise anywhere in the American government than there is in NTIA. We may be the only place in the federal government where a PhD in information policy sits in an office next to an attorney who's expert in the nuances of platform regulation and intermediary liability, and also intellectual property, who shares that office with a master of public affairs with 15 or so years of experience tracking digital equity issues and advocating for those issues, across the hall from a State Department alum who regularly works with colleagues across Asia on privacy and internet freedom issues. If you want to talk with someone who spent decades counseling online platform providers before serving as general counsel at the Department of Energy, you're in luck because he's here. And if you want to also talk with someone who did tech policy on the Hill for a decade or so, you're also in luck because he sits next to that other person. And if you want to add in the person who led advocacy for children's interest online at a major nonprofit for 20 years, or a former DoD expert in open and interoperable wireless networks, or an electrical engineer, or a computer scientist, or the architect of a $40 billion grant program, you're also in luck because all of them are down the hall as are alums from the FCC, from DHS, from NSC, from civil society organizations, from the media, from law firms, that's me, and from companies. So that's the value. There's a huge concentration of expertise in difficult tech policy issues and a multidisciplinary team that we're bringing to these issues and that I think are benefiting us and I hope benefiting the American people as we think them through. As I said, though, that's the value, but the values we bring are also important. And what I've learned since joining NTIA is that the interagency process that you hear about works well because different actors bring different equities to the table. And NTIA's equities are extremely well suited to the AI policy debate. There are many, but I'm going to focus on three before I close. First, we are, of course, focused on commerce and innovation. We're in the Commerce Department. NTIA knows that technological change can be disruptive and that disruption can raise alarms. But we also know that this change can offer huge advantages to the economy, to individual welfare, to public health, to individual health, to our international competitiveness and beyond. So the question we ask in the first instance is not how can we stop this new technology, but can we collectively establish frameworks that draw out technology's benefits while capping its harms? And that's one frame we're applying to AI. Second, we have a focus on national security. So the national security mission is pervasive at NTIA and throughout the Commerce Department. At NTIA, we see it in our work on Team Telecom, where again, we help evaluate transactions resulting in foreign control of American telecom infrastructure. We see it in our cybersecurity policy and our supply chain security work. National security considerations are integral to discussions over who has access to radio spectrum and under what terms, essential to our Open RAN policy work, which is now the subject of a new $1.5 billion grant program. It's even central in our broadband programs, where we recognize that our national security relies on our economic vitality, and that in turn relies on ubiquitous access to affordable internet access. And so too, as with all the other areas, national security is informing our AI work. We must consider here not only our own approach to AI, but what the stance is going to be of other countries, including, not limited to, but including digital autocracies that seek to use these technologies to surveil and repress their populations and to turn technical advances into their own geopolitical power. So national security is a key piece. And then we're focused on human rights. That's true, again, for NTIA generally, but I like to think it's especially true in my office, OPAD. I often say that we take a human rights first approach to whatever the issue we're talking about is. And so what does that mean? What does it mean to take a human rights approach to tech policy? Often when we think of human rights, we think of war crimes and displaced persons and, death and destruction. And often, hopefully that's not what we're talking about here, but what I'd say is that the human rights frame on tech policy means that we're always focused on what the policy will do to advance human autonomy, human dignity, human equity. It means protecting individual privacy. It means working to root out biases in our technological tools. It means ensuring that humans can understand the bases on which important decisions about their lives have been made, like decisions like whether they're going to be selected for a job or going to be eligible for a loan. And above all, this human rights approach means working within the bounds of the law to ensure that individuals have the liberty and the ability to chart their own course in life and build their own connections, their skills, their interests in the communities the way they wish to build them. That's really heady stuff, and one might wonder what it has to do with AI accountability. But to me, they're really closely connected. We want these technologies to work to advance human interests and expand our possibilities. And to ensure that they do that, we need means of allowing individuals to know, does this system do what it says? Have its creators adequately mitigated bias and other potential harms? Is the system set up to protect privacy? Given the millions or billions of bits of data used to train the system, how can I understand why it made a particular decision? And these questions are all amenable to evaluation, both before and after deployment. So when we talk about audits and evaluations and certifications and other mechanisms, we're talking about how best to make sure that AI systems are subject to evaluation when that evaluation would be useful, and that the technology does what it claims to do, and that it advances our objectives to improve our lives. So thank you for being here and taking these issues seriously. I look forward to discussing.
Thank you so much, Russ. It was a really helpful way to frame this, particularly for some folks who might be less familiar with all the inner workings of NTIA. I thought for a minute there that you were perhaps recruiting people to come and work at NTIA, and we will certainly be happy to offer you up as many law student interns from Georgetown as you would like to take anytime. So you're on mute, Russ, so I'm just going to continue here. I just want to throw a question or two in your direction, and then we're going to open it up for the whole panel. We also already have a few questions in the Q&A, so I'm going to tie that in as well. The first question that I have for you is, you mentioned, of course, that NTIA is certainly not by far the only entity within Washington that is working on AI. But even if we just look within the executive branch, obviously you're not the only executive branch entity working on this. The White House put together a blueprint for an AI Bill of Rights. NIST has the AI risk framework. So how does NTIA fit in with that? How do you work with other parts of the executive branch? And what else does the executive branch need to be doing, particularly things that are maybe outside of NTIA's remit?
Yeah, thank you. So I guess I'll emphasize at the start that I'm a career employee here, civil service, not a political appointee. But I think this administration is doing an amazing job on working through the set of issues, bringing relevant stakeholders to the table, and trying to act quickly. So it is true that there is very broad activity across the federal government, and I fully support that. Everyone who's involved is a contributor, whether they're looking again at a narrow vertical slice of the problem or across the board. And where we fit is I think of us as being on that horizontal side. We're looking across the board. We're not looking specifically at what the rules should be on to prevent employment discrimination, or to prevent or to ensure that new medical devices are tested in a particular way. That's not our expertise. Where our expertise really is in knowing how technologies work, knowing how the internet works and how other information technologies work, and create one ecosystem here. Thinking about, again, the commercial aspects, the security aspects, the human rights aspects, and being in the room. Again, I mentioned these interagency processes, and a lot of what we do is sit on calls like this or in person sometimes and say, I hear you about this concern your agency has. We have this other concern. Wouldn't it be, I think we can get most of what you want, or almost all of you what you want, and also get what we want if we did this slightly differently. So I think what we bring, maybe more than anything, is the ability to explain how technologies work, explain how technology and society works to folks who are more focused on other issues, and then finding better solutions, what economists would say, Pareto superior solutions, like where nobody loses but people can win, or we can win more. And I think that that's what we will continue to see. I do not, well, who knows what will happen. I do not foresee suddenly having regulatory power, but again, what we have is the ability to talk to stakeholders and then talk with government colleagues and to push the debate forward and make sure that certain considerations are accounted for. And although I can't disclose particular conversations, I've seen it work. It's kind of amazing because, Natalie, you and I both come from an FCC world, which is a rules-based world, an enforcement-based world. And with no rules and no ability to make rules, one might say, where's the power? But it turns out when you're sitting in a room, reasonable people can be reasonable, and expertise can win out and can lead to better solutions. And I've seen that before, and I'm seeing it here, so I'm happy about that.
Great, thanks. I have a feeling that in just a minute, some of our panelists are going to want to follow up with you on your answer to that question. But before we get to that, let me quickly jump from US government to a question about the role of the United States globally with respect to AI. Do you think that the United States government is a leader in ensuring that AI is harnessed for social good and that harms are kept in check? What do you see as models, elsewhere in the world that you think are good? And then pulling as well from some questions that we have, as I mentioned already in the Q&A, what are your thoughts on what the EU is doing, what the Council of Europe is doing, and is there any interaction currently or anticipated between NTIA and those entities?
So I'm pleased to answer some of those questions. So are we a leader in this policy area? Absolutely, yes. I think there's a misconception in some quarters that the US is not a leader here because it is not, in the final stages of adopting an AI Act as the EU might be, or because it has not adopted a national law like this country or that country. But I think that is I think that's a misperception. I mean, it's true we're not in the final stages of adopting this law, but we have a huge amount of thinking going on both in Congress and in the agencies. And that includes the executive branch agencies, but also independent agencies. So for example, just to take an example, a few months ago, the Federal Trade Commission, the EEOC, and a couple of the CFPB issued a joint statement essentially saying, hey, remember, we have these authorities over our respective spheres of influence. There's nothing about AI that's exempt from all that. So if you engage in unfair or deceptive trade practices involving AI, or if you're engaged in employment discrimination, et cetera, we're going to take action. That establishes norms and reminds people of enforceable law. Separately, we have we have a rule of law generally, and we have an approach that governs AI in particular contexts, even if, again, we don't yet have an AI Act. And what we see, and what I see, is people from other countries coming and saying, we want to chat about these issues. We want to talk, and we want to hear your vision. So we're a leader in the sense that even if we're not on the verge of adopting some sort of legislation, by the way, we might be. Many people in Congress are working on it. So who knows how long it would be if they did want to move in that direction. But what we see is people coming to us and saying, let's talk about the ideas. And then you see, Secretary Raimondo, my ultimate boss, meets regularly through the TTC and another fora with international partnerships. And she has, don't know exactly what I should say here. I think it's been reported that she has conversations with high-level counterparts in the EU and elsewhere about these issues and are thinking about ideas, and people have read online about the proposals being made by various individuals. So I think people know, if for no other reason, that the US is, by virtue of the huge economy, by virtue of the technological expertise, and the fact that many of the biggest companies involved in this space are here, we are leading. That said, can more be done to think about governance and accountability? Yes, and that's why we're doing it. Sorry, you did have some other questions. I just let me just jump to your last question, which are thoughts about cooperation. And I want to assure everyone, we are in deep talks with our partners in the EU, in Japan, et cetera. I think folks following this saw that in Hiroshima last month, I want to say, but maybe it was earlier this month at the G7, there was sort of an agreement to take up AI as a G7 issue, and what's I think seems to have become called the Hiroshima process. I wouldn't say every day I'm talking to foreign counterparts, but every day or every few days, either my office or the International Affairs Office or others are having calls and fielding inquiries from across the world. I am actually heading Monday night to Geneva for the AI for Good conference, which is put on by the ITU, and looking at how AI can be used to advance the Sustainable Development Goals. I'm really excited for the opportunities to talk to people there and hear about these uses, in part going back to what I said earlier, to my view that we have to be aware of the harms, but also recognize that there's a lot of potential for innovation and human good here. And I think it's important to keep those both in mind when we start thinking about how to synthesize a framework to draw out the best while capping the worst.
Okay, thanks. So let's just stop there for a second, Russ, and take those two questions that we just posed to you, open those up more generally to the panel, either thoughts from any of you about whether the US is a leader and how we might be working with other countries or following other countries' models here. And then also the question of whether the executive branch is doing as much as the branch could be doing on these issues. Should there be more? Where would you want to see that happen? Or feel free to direct more questions to Russ. Anupam, you're going to kick us off?
Sure. Russ, thanks so much for a fantastic opening discussion. I'm delighted to see the NTIA taking this step and receiving all of this input. 1,400 plus comments is a huge number, and I read through a smattering of them from industry associations, from individuals, from all kinds of groups. It is a fascinating array, and I think it's useful to get the kind of the brightest minds of the country essentially offering you free advice on how to proceed. And lots of people just saying, no, we shouldn't even allow AI, et cetera. We shouldn't allow it to be used, et cetera, for because of employment concerns, et cetera, which are obviously serious. The one thing that struck me about your description really was the national security being a significant part of the story. I didn't get that reading from the RFC itself. National security is mentioned a little bit as trustworthy AI as part of a national security strategy. And I have a general concern with our technology policy that again and again, it seems to be putting national security in some broad frame as at the forefront. And it's not clear to me, and you in your own remarks said something interesting, which is, economic progress is of course part of national security. And you've got companies like NVIDIA saying this morning or yesterday, the news this morning is that NVIDIA worried about even further expansions of export restrictions on NVIDIA's chips. Going to an additional set of chips. And NVIDIA saying, basically, we're going to lose out in the whole Chinese market. And the worry then that there's going to be, of course, what you've done effectively is made American companies unreliable as part of the global supply chain. You've said, if you put in more and more export controls that are broader and broader, it makes it harder to position American companies as the leading suppliers in that supply chain. And it's hard also when, to me, the concern here would be, there's the chips part of this, but a lot of the authorities here also apply to services. So one could, so there's the goods authorities that are being relied on for these export controls, but those authorities generally extend to services. So you could basically make all American companies insecure, unreliable partners inherently by the uncertainty of the economic export controls. So I want to raise a caution, and that would be one way to really not be a leader in global technology is to make that kind of So that's that's definitely more of a comment than a question. But I would I'll leave it at that. Your thoughts on that?
Yeah. No, I appreciate that. So let me answer both kind of the general point and the more specific point. On the general point, I would say national security is one of the equities that we bring to bear on questions. There are agencies, there are departments within the US government whose principal focus is national security, or whose principal areas of focus are national security and law enforcement. And what often winds up happening is we're in discussions with them and we're saying, we get where you're coming from, but if we destroy the internet, if we destroy the innovation ecosystem, if we destroy X, Y, or Z, our long-term goals are not met. And there are areas where we are not their enemy. We're working together. We're partners trying to reach a common view, but where those are sort of how the equities play out. I see it again and again. And what I often say is, it's not that we don't account for national security. It's just that we account for other equities as well, or take a broader view of national security. So I don't want anyone to hear me say that national security is trumps everything, or a particularly narrow view of national security trumps everything else. And I think you're right, that national security is less of a factor in this particular request for comment. I think it's in other parts of the AI discussion going to be more of a factor. The White House runs numerous processes right now on AI, and some of them are more focused on one issue or more focused on another. National security is one piece of that puzzle. That's the broader issue. On the specific issue, I'll say we at NTIA don't handle export controls. That's BIS, the Bureau of Industry Security. We also don't do the CHIPS program. That's the CHIPS office, which is, I guess, technically part of NIST. But the fundamental point about export controls or trade limitations or economic sanctions, for that matter, is that they are almost by definition curtailing transactions that would otherwise have occurred, right? Because if they would not have, then there's no need. And I think that there's been increased recognition that there are cases where either for economic or national security reasons, it makes sense to curtail certain transactions. There's sort of I think there's some recognition that in some cases that makes sense. I'm not well equipped to draw the balance. Those are the people who are expert in those areas. But sure, I hear the point. At some point, you have to consider what is being lost as well as what is being gained by curtailing a transaction that was otherwise economically or otherwise efficient to make.
Yeah.
Hey, yeah, I think so. I think Anupam's point brings up a good point in that in any kind of policy right here, like the thing that seems challenging to me in this whole area is that both usually like either the stakes are small on one side or there's a potential huge cost. But in the context of AI, the benefits are potentially tremendous, right? In terms of economics, in terms of innovation, in terms of transforming, just the way we live, the way we work. But the costs are equally huge. Worries about job loss and other worries about just losing control of this technology. And combining that with the fact that we really don't know how a lot of this technology works. I'm curious to sort of hear thoughts of you, Russ, and others about like how the fact that, audits and accountability are good, but if you put in experts and they can't actually tell how the technology actually works itself, that's like a fundamentally kind of different challenge than like, sending in auditors in other contexts where we have a better grasp of what the technology actually does. So I have some thoughts on that I'll share later on. But, combine those three things with the fourth factor that this technology is moving extremely fast. I'm just curious to hear the thoughts about like how do we go about balancing that? I don't think there's an answer easily right now, but I think that's really what we have to grapple with. And just looking at some of the other frameworks that I've seen announced by the U.S. government. For example, Senate Majority Leader Schumer has this safe innovation framework that he announced like a couple weeks ago. Yeah, I think they're trying to balance these different things, but it's a challenge. I don't know what the panelists think. If there's any sort of thoughts on what do we do? How do we approach that problem?
I've spoken a lot, so I want to open the floor to anyone else who might want to respond to that.
That's a difficult question, Neel. I mean, you've just asked how to balance these things, I think. And the questions of accountability and auditing are obviously central to the RFC itself. And so I agree with you that there is something kind of fundamentally maybe an impossible task, which is when you have these general purpose AIs, how do you assess the risk of those? Because they're as risky as human beings can use. And so how do you do a risk assessment? And I think OpenAI has been in conversation, of course, I don't know if you read the OpenAI's response to the EU AI Act, where they wrote a memo to the Commission about some of their concerns, and they're like, okay, we're a general purpose AI. There's definitely some bad uses of this. We know that. We don't license those uses. We tell people you can't do it, but those uses are going to happen, we won't be able to stop all of them, right? So how do you assess the risk at that point? What is a risk assessment? How do you do a probability distribution? How do you do any of that? I'm not sure. I'm not sure I trust the scientists who would tell me a number with that, right? Is there a number that we can offer for that? I'm not totally sure.
Completely agree with Anupam's point here that it's incredibly difficult to make those assessments horizontally. And I just wanted to add on to that by saying maybe that's just not the way to go about risk assessments. Maybe risk assessments need to be sectoral, need to be functional, and in doing so, they can probably better they can probably better reflect the types of threats that one might expect or one might need to prepare for. And if we try to draw analogies to earlier technological developments or even technological revolutions, I mean, who could do a risk assessment of the electric motor? Well, it depends on what you use the electric motor for. Who could do a risk assessment of X-rays? Well, again, it very, very much depends on what you use X-rays for. And so maybe a step forward here would be to do those analyses, to do risk assessments much more sectorally and take a much more functional approach.
Just adding to what everyone's already said, some of these risks will only come forth after the fact and often at personal risk, sometimes by whistleblowers. So key information and key goals of transparency might only be achieved if there are protections in place for people who might be opposed to the very risks that or the very activities that companies are engaging in. And I wanted to tie this to what Russ spoke about collaborating with private companies, about learning more about supply chains, how security or privacy concerns might be emerging at different stages, how to figure out when to intervene, whether it's development, deployment. So I also wanted to hear Russ's thoughts on how transparency proposals are being thought about, and whether there will be different sorts of requirements for certain kinds of companies, certain kinds of technologies. Are there protections for whistleblowers? Are there different stages at which transparency would be required? I'd love to hear your thoughts on that.
Sure. So I'll just emphasize up front again, we impose no requirements. So there will be no, we will not be in the position of saying, this is the transparency required here. We could recommend that those with legal authority adopt requirements. And I think that, look, we have to read the record, so I don't want to speculate too much, but I suspect, consistent with what many of you have just said, that context is going to be very important. And we have to think about, and one thing we have talked about is how we have to think about transparency different for different audiences. So there's transparency for a developer community, transparency for an expert community, transparency for policymakers. Much of our economy runs on the idea that consumers can balance benefits and costs and make a choice in a purchase or use decision. And that model works a lot better in some areas than it does in others. NTIA, through my office, filed comments with the Federal Trade Commission a few months ago saying that notice and choice in the privacy context online is not necessarily worked out. And in an area like AI, which just may be too complex and sophisticated for it to be worth an individual consumer's time to really figure out, we have to think about what transparency means, and are there ways of ensuring meaningful transparency? If so, what are they, and what kind of recommendations should we make? If not, what do you do in lieu of that individual choice, and how do you help consumers and users make decisions? So I think transparency is important. I think transparency is probably context dependent and audience dependent. And I think we have to be realistic about when transparency can and cannot facilitate the best choices.
Russ, you've mentioned a couple times some of the limits on what NTIA can do just because of its role, not on this issue in particular. There's a lot of discussion now, particularly with the introduction last week of a bill on a bipartisan, bicameral basis that would establish a commission to consider the right type of governmental structure to regulate AI. So I'd love to hear your thoughts, Russ, as well as others. Is there a need for a new federal agency here, a new federal department? If so, just AI or more than AI? What would it look like, and what would it do?
Yeah, so my answer there depends on whether I'm going to be the chair. Or any of the other people on this panel. No, seriously. So I don't have an answer to whether there should or should not be an independent agency. I think generally having policymakers with technical and policy and economic expertise is important. So I think that to the extent we can collect that that set of expert and the broad range of expertise that I'm talking about, computer science PhDs like the one I think is listening who works in our office right now. Like we need people who really know this inside out, and whether they are advising on legislation and creating new statutory rights of action, et cetera, versus an independent agency, I don't think we're there and figuring out yet. I come from an FCC background before I was here, and I think there are some benefits to that. But there's also, and this was inherent in your question, Natalie, there's a lot of discussion. I actually meant to print it out so I could hold it up at this point in the conversation, which I suspected would come. But I've seen a lot of talk recently about Frank Easterbrook's 20-some-odd-year-old article about the internet and the law of the horse. Right? I forget if that's the exact title, but where Judge Easterbrook was arguing, like, look, we don't need internet law. We have law, and it's supposed to be generally applicable. I think those debates have yet to fully play themselves out. There are aspects of this problem that are very specific to AI that require a deep degree of expertise, not just in the things I listed, but I can go on and on, behavioral economics and ethics and all kinds of disciplines. I just don't know if, is it that we need that to be an agency? Do we need that to be more expertise housed in places like the Federal Trade Commission? Are the jurisdictional bounds of those agencies too limited to get the interests we're trying to protect? So this is all a big way of saying, I don't really know. I think a lot of thinking has gone into this and should go into this. I don't yet have a great answer.
Can I just pick up on that, which I think that's a wonderful response, and I think we should approach this with humility and not kind of already have prejudged the answers. You've done 1,500, you've got 1,500 comments that are all over the place. You've got to think hard about this. You've got to ask the question: is a law of AI the most sensible way to think about? And we know that AI is going to produce harms, right? That is, but as Nick pointed out, we wouldn't say there's a law of motors, but I do teach an internet law. I do think that there is a there for internet law, but we don't say that there's a law of electric motors. So, by the way, there is some kind of law of the horse. There are some specialized laws of horses. But I think we're trying to figure this out, and I think there's also a kind of race to be the first regulator, the race to show that you are, you're in the lead. There's a kind of regulatory competition in a weird way, and it's not clear to me that being first is being right. China's already regulated AI. China already has broad AI regulations. No fake news. No, undermining Chinese socialist core values, all those things. No, you can't do deep fakes. That's impermissible. All those kinds of things, are already regulated. The fact that China is already at the forefront doesn't mean that they've got it right as well. So I appreciate the humility of let's, we're still learning, and I think even professors, I think, are largely just still learning. Mehtab pointed out, we can't even imagine the wrongs that are going to be done. And so then the question is, do we just shut this technology off, the precautionary approach, and so that we don't allow it? I don't know what the answer is, but I think those are all the questions that we should be asking.
Neel.
Yeah, I mean, just thinking from like a law professor standpoint here, right? I kind of think of it as like an analogy, like, okay, are we going to let the law kind of evolve in like a common law sort of approach, let different agencies develop their different approaches? Like Nick pointed out, it's going to be very sectoral. You want expertise from across the government, across, you want private industry to be able to regulate itself to some extent. It's going to take a mix of things. There's going to be international cooperation. You want to see how things play out. There's going to have to be some element of that. On the other hand, right, you don't want there to be a huge gap, right? Just everyone's looking in their area and there's like a huge gap that's missing, right? So I think, the kind of stuff that NTIA is doing, it's very useful to be like, not just now, but in a year or in 2 years to see, okay, where are the gaps? Okay, we've got some regulation in place, some existing laws, right? The law of the horse, okay, whatever. We have some laws in place already. We have some new laws in place. We have some new regulations, but to really be cognizant of those gaps, because that's where real problems might arise. And again, because the costs here are potentially so huge, we have to be more vigilant about that than we would be in other contexts. So I think the end solution is going to be a combination of decentralized and some sort of kind of central view of like major harms that might emerge. But that's a prediction. I don't know.
Neel, the first part of your response made me wonder, because it sounded so much like some of the discussions about regulation of privacy and the continued lack of that on a really broad basis. Have we learned any lessons from what has not been done with respect to consumer privacy and from what has not been done with respect to social media? And if we have learned any lessons, are we going to do anything about them?
Well, I'll just throw one thing out and leave to let others talk. I mean, I do think that this is a time when the winners and losers in AI policy are not so clear, right? If you introduce a regulator, the industry is asking to be regulated. At some point, that might stop, right? When sort of the winners and losers of a policy become clearer, I think there's going to be harder to actually get things done. And so, there is, in some sense, it may seem premature, but there's an advantage in moving a little bit quicker right now before kind of it becomes clear that people's personal stakes or financial stakes are going to be against a particular regulation, even if it's in the social interest. So, I think in the privacy and in other regulations, we've seen that, right? In internet regulation. And I wouldn't be surprised if that happens here. So that's a cautionary tale.
Yeah.
Oh, I'm sorry.
No, please.
And again, just adding to what's been said here by Neel, there might also be an additional argument, which is that if you move a bit earlier, you preempt the sort of lobbying industrial complex from emerging in the first place. So not just the aspect of winners and losers becoming clear, but also just the buildup of infrastructure that in the longer term or the medium term preempts regulation.
Russ, did you have something on that as well?
Well, to that point, I was going to say, I do sense that there's a lot of discussion that's prompted by individuals' interest in the issue, not yet sort of the where do I stand to benefit from this. I see that in a number of places. I see it a little bit in our comments where you might expect a particular entity to have a certain set of views, but instead of that, you see them just sort of groping for what's the best answer here because it's an intellectually interesting issue and the equities have not yet, the financial equities have not yet sort of solidified.
So with an eye on the clock here, let me ask one question that is in the Q&A, and then we'll just go around and sort of have some final thoughts before we close it out. I think this question touches on something that you all very lightly touched on previously, but let's go a little deeper, which is how would horizontal AI regulation work vis-a-vis vertical AI regulation? So for example, if the FTC can protect consumers against fraud using AI, and the EEOC deals with AI that results in employment discrimination, what might there be left to do that is only AI? This sort of, is there a standalone law of AI? Any further thoughts on that? I know we did talk about it a little bit.
I mean, my answer to that would be, it could be. I'm not saying normatively whether it should be, but if you imagine there are regulated industries, and let's set aside common carriers, because we all know the FTC doesn't deal with common carriers, but there are regulated industries that are subject to particular requirements. And if I'm a regulated entity under one of those, but not a common carrier, I might still do things that are subject to the horizontal regulation that is Section 5 of the Federal Trade Act, right? Where if I do specific things that violate a regulation, I might see enforcement action or a case by the sector-specific regulator. But if I do something that's just more broadly deemed deceptive or unfair, I could be subject to the broad horizontal regulation. In theory, one could see something like that here too, where if you violate the EEOC's employment discrimination regulation, then you're on the hook for that, but you might also be in violation of our broader AI laws, whatever its just and reasonable practices requirement is, or so forth.
So I'll ask a final question to each of the faculty members of the panel. And Russ, you hold off for just a second because this question is designed to elicit some information for you. No, you can listen. It's just not for you to answer, which is Anupam, Neel, Mehtab, Nick, from your scholarship and your experience, what is something that you think about governance of AI that policymakers might be missing? And what is something, if you had, for example, submitted a comment in Russ's proceeding, what do you want to make sure that he knows?
I guess I'll lead off, and this is for the audience. We weren't given the questions beforehand, so I'll just shoot from the hip here. I guess it was interesting to me in reading the RFC that IP is not actually isn't a central question. It's mentioned once in a long question. It's not about, so I'm actually surprised that copyright isn't kind of driving much of the concern, because of course, with many generative AI systems, they are consuming copyrighted works as part of their learning process. And then they can even produce things in various styles. You can say, write me lyrics like Taylor Swift's or Johnny Cash, or whomever your favorite singer might be. And then soon we'll be able to produce music, et cetera. So that technology is coming. I don't know if we as a society have figured out what the rights and wrongs of that are. And it's just going to be fascinating to see. Also, another thing that does get a lot of attention in your paper, in your RFC, is privacy, which I think we really don't have a national privacy law, first of all. So it's so there is now, as you may have seen, a lawsuit already filed under the California privacy law to kind of a class action. That's an effort, but apparently it's early reads of the complaint suggest that it's a mess, according to the scuttlebutt on the cyber prop listservs, at least. So you've got these two existing bodies of law that really could stop the engine on the tracks right now. If copyright proceeds, if privacy proceeds, you really have, if these are successful claims, you can stop most of these systems, and get rid of them. So it's an interesting kind of existential question that I think American litigation is going to be testing over the next couple of years at least. And that's your common law approach to some extent, Neel. We do have a very interesting and significant system of testing new technologies against existing law, and that's going to be really fascinating to see how that develops.
I'll just jump in quickly because I might actually have to go do a child pickup in about a minute here. But I think one thing is, I do some work on FDA and FDA approval in the related to IP. And I think the FDA approval process, there might be some lessons that are useful in the IP setting, right? So the FDA approval process requires some early stage filings, these investigational new drug or IND filings, and that requires some sort of safety and efficacy data. The analogy in the AI space could be data that developers need to submit or approval that's needed before training of certain systems, right? And then there's obviously later stage filings, right? Before actually deployment, before actually, the drugs can be used. And these are related to NDA filings. An analogy in the AI space might be filings required post-training, but prior to sort of deployment. So I just think that there might be some useful analogies in areas where there's also high stakes. There's also potential for harm and also potentially huge benefit. Like we might be able to think creatively by analogizing from other areas where we've dealt with, I wouldn't say similar regulatory problems, because I think AI is unique in some sense, but other really important regulatory problems.
I would actually echo what Anupam said about IP, because I think copyright is something that the public is increasingly concerned about. Different industries and sectors are threatened by emerging IP issues, especially the creative industries. And it is something that companies are going to face as an obstacle or like a question mark. So I think mapping out what exactly the IP concerns are and how they're likely to impact different kinds of people, like even like basic ways by which they can engage in commerce and in their skills of trade or whatever industry they're part of. I think that needs more attention.
Nick?
Just continuing that, I think one of the crucial points that will need to be settled rather early, and is also one that might or might not fall into Anupam's category of emerging common law, is our liability questions for content. We have seen emerging discussions around Section 230 as it is applied to AI, generative AI. We've seen claims that it is or it is not covered as speech by the First Amendment and the guarantees for free speech. And I think those decisions will set the tone for where text-based AI is headed for at least in this sort of medium term or short term.
Thanks. And Russ, you get the final word here, of course, which is really the choice of two questions on your part. Either something that you would like for the members of the panel and for others who are listening on the webinar to know, to think about, to internalize in terms of either work that the government is doing or AI issues in general, or alternatively gaps that you think that NTIA faces and perhaps others in terms of information that's available to you and that you would want to hear from people.
Sure. So I think I'm going to be closer to the second question, but I may repurpose it. I will say, as I said before, we are as strong as our ideas are. I'm blessed to work in an office with lots of curious, really smart people who have their own interests and pursue information, but we really do rely on the information that folks bring to us. So I wouldn't say that we are lacking particular information, especially can't say that not having read all 1,440 comments, but I really strongly urge folks to come to us if you want to have a meeting with us, if you want to supply us with information. Can't say we do every one of the meetings we get asked to do, but we are generally in a mode of trying to interface and make connections and learn. So please, our door is mostly open in that regard. And anyway, so I urge people to do that. And by the way, if you're a student watching this, that applies to you as well. And if you want to have coffee or a virtual chat with one of us, and please reach out. We're just people. So please do that. In terms of what I want people to know, there's a phrase I've been using a lot lately, which I originally heard from James Carville somewhere, and I forget. I think it's a more common phrase, but the phrase is the axiom is the best time to plant an oak tree is 25 years ago, and the second best time is today. And I feel like we're now, or we have recently begun really planting. This work has been going on for a while, and I should have said my office, Mehtab, was working on AI before I set foot in NTIA, before ChatGPT was anything anyone talked about. But there's really a huge amount of work being done now, and it's important to do that work, even if it doesn't mean we're going to have a fully formed legal framework in a year or two. We don't know when that will come, but the work is what's important. And the oak tree, by the way, here is not not necessarily an AI regulator or a specific kind of AI law. The oak tree is a developed body of thought on these issues that does draw on the traditions and analogies, that does incorporate deep thinking about technology, and that does account for equity and so on. I could go on for a long time, but that's what we're building here. And I'm really glad that everyone here is part of the conversation. We need really all the best brains to be thinking about this issue, all the best biological brains to be thinking about this issue, and look forward to more conversations like this.
Great. Well, thank you so much, Russ. You've been very generous with your time. I know we've kept you a little longer than we promised that we would, but really appreciate your being here with us today. Thank you as always to Anupam, to Kyoko Yoshinaga, to Mehtab, to Artur Pericles Montero, to Nick, to the Tech Institute and the Centers and Institute staff at Georgetown Law. It's really our pleasure to be able to put on this AI governance series. Encourage everybody who tuned in to keep an eye on our website and social media for what's up next. Thanks, everybody. Have a good day.
Thank you all.
Thanks so much.